people of India,
we the people of India,
having solemnly resolved to constitute India
having solemnly resolved to constitute India
into a
into a
sovereign socialist,
sovereign socialist,
secular democratic republic,
secular democratic republic,
and to secure to all its citizens
and to secure to all its citizens
justice,
justice,
social,
social,
economic and political,
economic and political,
liberty
liberty
of thought, expression,
of thought, expression,
belief, faith
faith,
and worship,
and worship,
equality
equality
of status and opportunity,
of status and opportunity,
and to promote among them all
and to promote among them all
fraternity,
fraternity,
assuring the dignity
ensuring the dignity
of the individual
of the individual
and the
and
unity and integrity of the nation.
the unity and integrity of the nation.
In our Constituent Assembly,
In our Constituent Assembly,
this 26th day of November,
this 26th day of November,
1949,
1949,
do hereby adopt,
do hereby adopt,
enact and give to ourselves
enact and give to ourselves
this Constitution.
this Constitution.
Thank you very much. Students, I am also privileged to be here, to be able to share my experience with you. Now, I am a man on the field. I sow seeds, the plant grows, it gives you the flowers and the fruits which we all consume. I am absolutely a man on the field, doing things practically, what we study. That way, I am not an academic person. You may have academic questions. Your learned and esteemed teachers will have been able to, and they do, clear your doubts and questions. Why law? Or why you have pole science and law? This is the combination, I believe. Okay. And tell me why we cannot live alone individually as human beings. So this was like we can't live alone. We had to form. We were first nomadic tribes, then we formed societies, then states, the countries, the continents, the civilized society, the state concept, the political state concept, how it all got evolved with the passage of time. I don't know whether you will have a scope of e-book reading. I don't know whether these books are available. Two books I can suggest, both of Indians. One is Our Growing Human Family by Minu Masani. He was a 3-time member of the parliament of Swatantra Party. So Our Growing Human Family, that describes how from individual human beings, being a human species, how we gathered as tribes, developed ourselves to transformed ourselves to civilized people. We formed societies, civilizations were created one after another, and after that the state emerged. The creation of state is a political concept, dates back to the Romans and Greeks, as you know. So Our Growing Human Family by Minu Masani, the 3-time MP of Lok Sabha, depicts this picture very lucidly. And another book I would suggest is Letters from a Father to His Daughter, no other than our former Prime Minister Jawaharlal Nehru writing to his daughter. This also depicts the evolution of the process, the history, the social and cultural milieu, the economics of our country as well as of the entire world. Now, this book was written while Nehruji was in jail in different forts in custody during the freedom movement. So these two books actually I referred gives us a basic idea of evolution of civilization, of history, of our culture, of our economics. Now, why do I go for this in an interactive or a lecture session of political science and law students? This you might wonder. The reason being, there was a Renaissance in Europe between 1400 and 1600 AD, you all know. You have heard about the Bengal Renaissance. You must have studied. You have studied about the Derozio, the Derosians. I don't know whether you have studied or not. In Hindu school, a young professor who influenced the students to that extent that they started debating, arguing their own culture. And what I intend to say is, the subjects are so interrelated. There is a philosophy behind every subject. The philosophy of law, whether it is the Western philosophy or the Eastern philosophy. The philosophy of law or the science of law, which you would like to, which you will be reading, or maybe you have read. How many of you are from class 11? Can you raise your hands? And the rest are class 12. Okay. So class 11, and how many months in class 11 you have completed? 4 months. So you have just started reading your, I've gone through your syllabus also. And the class 12 students, they have already covered a year's academic pursuit, so they are better placed that way. So as I was telling you, the subjects are so interrelated. You will be learning jurisprudence. You will be learning jurisprudence, or maybe you have learned jurisprudence. And that is the science of law, the philosophy of law. The question of philosophy comes. So philosophy becomes related to, the subject we are discussing, be it the law or the political science. Chiefly I am to give you a lecture on law, but how it is interrelated, this I would like to tell. Similarly, you have to know the history of our country and of the nations, the modern history especially, during the British period, and of the world as well. A prima facie knowledge of the history. At the same time, those who have taken up political science with your legal studies, they go side by side. The political science, as you understand, now without knowing Voltaire, Rousseau, Locke, Hume, Bentham, Mill, we cannot have an idea of the political philosophies, of the state concept, of the concept of justice. And you know, that our constitution, when it was made, a brilliant constitution, the elephantine size of this constitution, it has described, it has borrowed, but assimilated, not merely borrowed. I would rather say it has assimilated from the best constitutions of the world, whether written or unwritten, and the class 11 students studying, you have started. So that's good, that's good. And to 12, you have already covered that. So the thing is, the constitution is the mother of all laws, it is known as. But this was very recent. In 1947-49, you know, regarding the birth and evolution, not the evolution, the birth of the constitution. That I'll come to you later. That is purely academic. What is important is the Constitution of India, prior to that, how the governments were run during the British period, and without having a constitution, even how nations in different parts of the world that used to be run. So is a constitution so important? Even the most advanced nation like Britain, it has an unwritten constitution. You all know. In India, during the Mughals, the court language was Persian, Farsi. We have the very word Adalat, the very word Shirista, that means where the office of the judge or the lawyer. There are many words which still remain with us, were used in the court. That was the court language. This Persian, in Bengali it used to be called as Farsi, right? Thereafter, with the advent of the Britishers, the Portuguese came, the Dutch came, the French came, but they did not stay. All came for trade and commerce. Then in 1690, as you know, a ship landed in the bank of Ganges. It was a rainy day. It was Job Charnock's ship, and in Calcutta, that is the beginning of the East India Company, which only came to trade, but finally they ruled for 250 years. Now, during this entire period, how governments were run, there were no consolidated laws. Only during the time of Macaulay, the Indian Penal Code, that was the first codified law, consolidated. He was the chairman of the Law Commission, and during that time, Macaulay, and there were other British civilians, so they had sort of gone for framing laws and finally enacting them. And as you know, after the Sepoy Mutiny 1857, so the prima facie knowledge and the datings of history, these are also these are to be remembered. After that, the Queen of England took over the ruling part of the Indian continent from the East India Company. It was no more in the hands of the East India Company, right? Britishers were already in, the British government was ruling. The necessity and need for codified laws. So the Indian Penal Code, the Criminal Procedure Code, and the Evidence Act of 1872, I believe. 1860, the Indian Penal Code. So these three laws were enacted, formulated, and with those the government started functioning based on those laws. So that was very important. Much later, in 1908, came the Civil Procedure Code. Now, after all this, what was important is we were no more ready to accept, the Indians were no more ready to accept the British rule. So the freedom movement started, and during the freedom movement, the British laws, many of the British laws were found to be oppressive, which needed change. As you understand, particularly the 124A, the sedition, waging war against the government. So the scenario, the context had changed. So it needed a revision. It needed a complete change. Whatever has come up with the new three acts, three laws. One is the, as you know, that BNS Sanhita, you will be the Nyaya Sanhita, then the Nagarik Suraksha Sanhita, and the Shakshya Adhiniyam, that Evidence Act. Now all these three new code and act, these sort of had a, what I find, right, there has not been any sea change. Basically, most better part of it is old wine in new bottle, but then certain changes have been made. The three old acts were very old, it needed change. So the change is always a welcome, is always welcome. Change is the sign of life, we should always welcome change. But the situation and condition as debated, I am not going into that argument or debate, but the situation and condition under which, without giving an opportunity to the opposition, as alleged, again I say, I am not going into that debate, as alleged that without giving an opportunity to the oppositions, the bills were passed. So those became acts. And naturally, the debate would always continue whether it required the present acts, whether those required more debates and discussions for its betterment, for its change. Now, let me go back to those days that after the Quit India movement, as you know, in 1942, which had only accelerated the reaching the Day of Independence in 1947. During this period, the governments also changed. Clement Attlee had come in Britain. So there was a Cripps mission, as you know. And the Constituent Assembly, in terms of the 1935 Government of India Act, that's a very important act during the Britishers, though there was no universal suffrage, adult universal suffrage, voting for the entire adult population was not there during that time. So the members who were elected in the provincial assemblies, those members elected or formed the Constituent Assembly. So this Constituent Assembly in 1946 it started functioning, it started debating. There are volumes of books. In fact, the entire debate consists of some 20, 30 volumes. And very important, that is the backbone of this constitution. Through debates and discussions of very learned members, the constitution was finally drafted by the drafting committee with Dr. Ambedkar as its chairman, as you know. Nehruji moved the objective resolution, which became the preamble later. And what is this preamble all about? This I'll tell you. I've seen very important, I was thrilled to see very important sections in your syllabus. The Keshava Bharati case. I don't know whether you have already started or not. That is in the work, your work assignment, or what you call it. Keshava Bharati case and certain cases. I don't know whether you have already, whether you have come across or not. Basic doctrine principle. I don't know. Have you come across? Not yet. Not yet. Not yet. They have not. They have not yet come.
For political science, not political studies. We have come across whether the preambles are part of the.
Yes, I mean the Keshava Bharati case. Yes. They have come across.
Yes.
Oh, acha.
Lighter.
Obviously. It's a huge document. So, what is important is with a fine fabric, you have your attire, right? Now, how do you clean it? How do you wash it? Don't you very carefully wash it? Your parents, your mother, maybe, or the person in charge of doing such things, the housemaid, whosoever, but very carefully a fine fabric is washed. Otherwise, it will have wrinkles, may get torn and tattered, right? So likewise, this fabric is very important. The constitution has its fabric, the basic fabric, the tenets. The preamble is the spirit, the soul of this entire constitution. It is a living document, and the Keshavananda Bharati case in 1973, I believe, N.S. Palkiwala, one of the leading lawyers of that time, internationally acclaimed lawyer, N.S. Palkiwala. I have met him a number of times when he used to come to Kolkata for giving his budget speech organized by the statesman. Erudite scholar, and what oratory, I must say, I remember. And he argued for 35 days at a stretch. And over 6 months, or for about 6 months, this argument for Keshava Bharati case continued. The basic doctrine principle. I was very thrilled to see that has been included in your syllabus, and not only that. Let me complete the earlier part. So the basic structure, the preamble, whether this can be, the basic structure, the fabric, the basic tenet, whether that can be changed or not by way of amendment under Article so and so, 368, that is, whatever. I am not going into that detail. Whether this can be changed or not, that was a fundamental question. And whether the parliament, as you know, the parliament, judiciary and executive, these are three organs and having separate independent powers. They have their own independence. So whether the Parliament has the unlimited power, unfettered power. So that was the question decided, and it had reference to the 24th, 25th and 29th amendments. What are those? I'll not go into details. Those amendments were, this was prior to 42nd amendment. 42nd amendment, as you know, there were certain changes in the preamble. That was very important. 42nd amendment is known as the mini constitution, popularly known as. So the thing is, the 24th, 25th and 29th amendment was also challenged in Goloknath case. What is that? I'm not going into that. What is important is the judicial power of the Supreme Court was somewhat curtailed. So that was under challenge also. So in 42nd amendment this was done. Keshava Bharati case, that was in 76, the 42nd amendment, during the emergency during Indira Gandhi's regime, while she was the Prime Minister. In 73, the Keshavananda Bharati case. In Kerala, there was a mutt, and regarding land distribution, certain problems cropped up. Kerala government had come up with a law. This was challenged by the priest of that mutt, head priest of that mutt, and that went to High Court. The constitutionality of that enactment, of that introducing that law, that was challenged. Now there, it went up to Supreme Court, and before Supreme Court, this Keshavananda Bharati case versus State of Kerala, Keshavananda Bharati versus State of Kerala, before the Honorable Supreme Court, this question was to be decided whether the basic doctrine, concept, whether that can undergo a change by the Parliament. That was the most important part, right? Now, this had a very far-reaching effect. We are all very religious people, or may not be always. You may be an atheist, you may be an theist, you may be an agnostic, we do not know. Some of us have the Gita as our scripture. We have the Quran as our scripture. We have the Zend-Avesta as our scripture. We have Agam. I believe the Jains, they know. Any student, Jain student? So that is a number of religious texts, Agam. Then the Granth Sahib is there for the Sikhs. The Kaur must be knowing it. Where is she? Oh yes. So Granth Sahib is there. But believe me, the 20th century Gita, the 20th century Granth Sahib, the 20th century Quran, this was enacted and adopted in 1949, November 26th. And 2 months later, the people of India had given to themselves, we give to ourselves, the constitution, which is the 20th century Gita, the 20th century Quran, the 20th century Granth Sahib, the 20th century Bible of ours. This is the most important thing, that the fabric, very delicate fabric with which it was woven, whether that can undergo a change by way of a majority in the Parliament, whether the Parliament can change it or not. So in 73, in the Keshava Bharati case, the Supreme Court decided, no, they cannot change it. You have a question in your syllabus, I find, maybe in the workshop or wherever, in the assignment you have to do, whether this Keshava Bharati case, if it had happened in today's scenario, what would have been the judgment? It's a very arguable topic, which I wouldn't go now. If we happen to have scope and privilege of further interactions, definitely we will discuss it that day. It's a very debatable and arguable thing. Let us dedicate this session to the democratic, socialist, secular Republic of India. And when I read only a few lines, will the students also read with me, line by line? We the people of India.
We the people of India.
Having solemnly resolved to constitute India.
Having solemnly resolved to constitute India.
Into a sovereign socialist, secular democratic republic. And to secure to all its citizens. Justice. Social, economic and political. Liberty of thought, expression, belief, faith and worship. Equality of status and opportunity. And to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November, 1949, do hereby adopt, enact and give to ourselves this Constitution. Thank you very much. This should be read and reread. And the fabric with which, as I was telling you, it was woven, it has to be taken care of with utmost caution. Reason being, it's a very delicate fabric, and the basic tenets and the fabrics must be upheld, and whether or under what circumstances those can at all be changed remains to be debated always. This is the preamble of the Indian Constitution. Now, as you know, the Constitution borrowed from many countries the best spirits, the best provisions, the best laws, assimilated them, and then it was put into our Constitution. And what is that? And what is that? You know, the fundamental rights, those have been sort of taken from the American Constitution, Constitution of the United States, the parliamentary government from the Constitution of UK, then the 1935 Government of India Act was given utmost consideration, though that was repealed in 1947 when the Constitution was enacted and adopted in 49. But then the parliamentary, the Government of India Act was given consideration. because that was the act in terms of which the government, the British government was being run at the relevant point prior to independence. And you know the directive principles of state policy, those were taken from the Constitution of Ireland. The established procedure of law, that was taken from the Constitution of Japan. Then there are from Canada and Australia also the federal structure, the concept. Those all were sort of taken and assimilated, and then those were put into our constitution. These are the imports. But this constitution was made according to the climate, the then climate of our nation. And the members of the Constituent Assembly who debated over this constitution drafting, each and every provision of the constitution, some 389 odd members, and after the partition some 90 members had gone, some 299 members remained with India. So they all debated for a few years, and it took 3 years practically. And after the debate, the drafting committee finally, under the chairmanship of the President of the Constituent Assembly was that time Dr. Rajendra Prasad, the first President of India also later. And this particular drafting committee, headed by Dr. Ambedkar, this prepared the constitution. The objective resolution was moved by Jawaharlal Nehru, which is the preamble. Now in this backdrop, the constitution, while this was made, this was given to ourselves, and India became our republic, country of the people, for the people and by the people. Now, this being created much later, even that becomes the mother of all laws. The constitution is considered to be a living document. It's like the sun, which goes on giving us the light, and which is a living star, as you know. You know your science and geography and the astrophysics, right? So there are blasts, and it continues to give you the light. The heat energy is converted into light energy. So similarly, this constitution is a living document which throws light on every other law, whether enacted before or after, which is followed in the country. This is the beauty of this constitution. It is stated in 1947, we got the freedom, but not the liberty. It was in 1949 and in 1950 when the constitution was given to us, to the people of India, with the concept of liberty. Article 21 you will find. No person can be deprived of his life and personal liberty except by established procedure of law. So this concept of liberty we got only after the constitution was enacted, adopted, and came into being and given to us, and when it became operative, the concept of liberty. Maybe under the IPC section, now it is nice Sanghati, the IPC will continue in case of old cases. So in case of the Indian Penal Code sections, a, or at the same time, simultaneously under the Criminal Procedure Code, a person is arrested, then the question of Article 21 will always come. Whether, to what extent his liberty can be curtailed, how long he can be detained, how long he can be forced to remain behind the bars. This will continue to be debated in terms of and in the light of the constitutional Article 21, though that was created much later. The thing is, in this entire context, the Constitution of India and the entire context, whatever you are learning, the thing is whether it has, why have you chosen this subject? That is one point to be discussed. And what are your aims and ambitions? Now make your target very high. Target is always higher than the achievement, then only you can achieve, right? What you want after completing your legal education as it is now, you have tremendous scope ahead. The facilities which you can avail in today's world, this was practically unknown to us during our times when we were of your age. Okay? So the thing is, try to get the best of it. You need the wit, wisdom, eloquence and everything. Knowledge, of course. So Antonio was in need of some money, and he sort of took a loan from Shylock the Zoo. You have read in Merchant of Venice. Now this was to be given to Bassanio. Now Antonio's time was out, because as per the agreed terms and conditions, if within time he could not pay, if he failed to pay, then Antonio had to give a pound of flesh to Shylock the Zoo. And Shylock the Zoo, they had old enmities between themselves, took every opportunity of that and said, no, since the time is over, I want that pound of flesh, not money with interest or nothing. So a pound of flesh. And then came Portia, as you know. Bassanio quoted her. Then came Portia in a man's dress, in the guise of a lawyer, in the guise of a man with a man's robe. The only thing which is argued before the court was 16th century Shakespeare writing. Just imagine. Yes, he is ready to give you a pound of flesh, but not an ounce of blood. This is wit. And what is wisdom? Socrates tutoring, giving tuitions to one of the nobleman's son, Lysis, in Athens. Socrates says to the boy, Lysis, don't your parents love you very much? Yes, the boy says. Then when you meddle with the wool of your mother while she is knitting, does she allow you? No, the boy says. Why doesn't she allow you? She loves you so much. The boy can't answer. The boy is very restless. So he is to be tamed, and then he is to be sort of calmed. So Socrates giving him the lessons. Then who takes you to the school? I have a servant who is being paid by my parents as a daily wage earner. He takes me to the school, holding my hand. Oh, then Socrates says, you are sort of under a slave look, your parents love you so much, you say, but then you are under a slave and you cannot move yourself. No, I cannot, really, Socrates. Then Socrates says, can you sort of drive a chariot? The boy says, will your parents allow you to drive a chariot? The boy says, no, the parents will not allow me to drive a chariot. For that I have a driver, a charioteer, whom we call, to drive it. Then you don't have the permission even to drive your own chariot of your own house. Then the boy says, then why is it so? If your parents love you so much, why don't they allow it? Then the boy says, I have not come of age. So that wisdom should be there. That wisdom. So this is very important. That wisdom should be there. There is a fallacy. The parents love you, but they don't allow you to do this and that. But what is fallacious? You have to make the person understand that what is apparently true, what is apparent is not real. So this is fallacious, and you make the boy understand. The boy says himself, you come to that point by cross-examining him. You reach that point where the boy finally says, yes, I have not yet come of age. So this is what we call wisdom. A camel is lost. So the man complains to the king, my camel is lost. Somebody has taken my camel. So one beggar was standing on the street. That beggar was brought before the king in the same route where the camel got lost. The beggar said, okay, fine. But I am a beggar. I don't have anything to tell you as such regarding the lost camel. But is your camel blind of one eye? He says, yes, yes, before the king's court. Is your camel limping on the left foot? He says, yes, yes. Was your camel carrying pitchers, one of which was very old and with holes? Water went out. Was such pitcher there on the back of the camel? He says, yes, yes. How do you know all this? He says, because in the same route I was traveling, I found that a camel must have gone by, but the grass on the left is not crushed. Only on the right it was found to be crushed, because the left foot he was limping on the left foot, so he could not sort of give much pressure on the grass. And thereafter I saw, because he's blinded of the right eye, I saw only the left side, a line where the grass was eaten, not on the right side. Because the camel could not see that side while it going. The weeds and the grass, only on the left side he has consumed. And there were watermarks from the old pitcher with holes from which the water licked. This is observation. This is observation. What I wanted to say is, regarding wit I told you, regarding wisdom I told you, this is observation. These are certain basic things which we are to have in our mind for while going for in future once you complete your law course academically, and after that what all you can do after completing your law. What are the avenues and scopes? Let me tell you that a little bit, because you must be very anxiously waiting to listen to that. True, somebody wants to be a litigant lawyer. Nowadays this term has come very much, but actually litigant lawyer in our times, this litigant lawyer and corporate lawyer, these were not there. Nowadays these things have come up. In class 11 learning law, this was beyond our imagination. So a litigant lawyer is, say, who practices privately, who runs the business or a show himself, herself, on his own. He has individual clients, like any other doctor, individual doctor in his chamber. Now let me tell you, before you streamline yourself as a litigant lawyer or a corporate lawyer, or being a litigant lawyer in the criminal field or in the civil arena, you have to know, if I go to a doctor and tell him that I am having a pain on my ear, will he straightway recommend me to a ENT specialist? No. If I go to a doctor and say that I am having pain on my knees, will he recommend me to visit an orthopedics doctor's chamber? Not necessarily, not necessarily. So a doctor, a general physician, he has to have a knowledge of the entire physiology. This is what I want to tell you. So once you have a knowledge of the entire physiology, you can, after that, in extreme cases, in severe cases, only a doctor refers the patient to some other specialist. So before you go for specialization, you have to know, or you have to have a prima facie knowledge of the entire law of the country, in particular, our country, I mean. So this is very important. And after that, somebody may always take up teaching. Somebody may go for a government job, right? You have the judicial examinations. After that, you can go for that judgeship. After you pass the judicial examination, you may have the appointment from the government as a judge in the courts below, as civil judge junior division or as a magistrate, and thereafter you will be promoted to the chief metropolitan magistrate or chief judicial magistrate or the civil judge senior division, additional district judges, and thereafter district judges, etc., etc., etc. High court judges are taken from two quarters. One is the person almost at the fag end of his career, a judge, who has been a district judge for last few important districts, including Alipur and Kolkata. And thereafter they are elevated to the High Court judge, they maybe few of them, and the rest of the judges, they are recruited from the bar. We all who practice from them, the senior lawyers are often given the opportunity, and there is a collegium system through which the High Court judges are appointed. That is not the issue. The issue is you can go for this judgeship, you can go for after passing your judicial examination of the government, say of the West Bengal government jobs I am talking about. You can go for, there are other works in the judicial department itself as officers. So there also we have excellent opportunities as government servants to serve the government, whether state or central. And apart from that, if you go for what we call, if you go for to be a corporate lawyer in that event. Now, for companies, they recruit lawyers to take care of their matters, who in turn get it done through other lawyers in the court or through the solicitor's firm which are engaged in by that company. It is not that the person who is engaged by the company, he or she himself goes to the court, he or she writes the petition or the brief, and then no. He has to have a prima facie knowledge of the law, as I told you, like the general practitioner, the house physician, as I told you. And then you go to the, when you join a company, the company cases basically, and the intellectual property rights cases. Now this is then, this is a consolidated form, the trademark and all these things. You can go for the environmental practice. Previously, before the chief judge only in Calcutta High Court, we used to have a bench only for environmental issues. Now there is a green bench altogether. Supreme Court has a national green bench, and there is a state green bench in Newtown where only environmental cases are dealt with. Pollution cases are dealt with, the environmental cases as such. Previously, through PILs, public interest litigations, the only jurisdiction was of the Chief Justice of the Calcutta High Court and his division bench, companion of justices. Now it is a separate bench altogether. So what is important is, you may even go abroad for your job, given an opportunity. You go to the United Nations or anywhere else. The thing is, after the First World War, the League of Nations was created, as you know, the League of Nations in 1920. The First World War was between 14 and 18, 1914 and 18. So after that, in 1920, for better cooperation, the first League of Nations was created. But that finally failed, that did not serve the purpose, and finally the judicial, and finally during the Second World War, between 1939 and 45, you know, the Hiroshima, Nagasaki incidents and all this nuclear holocaust, etc., in 45, at the last stage, Japan surrendered, etc. Now this part of history is also very important. After that, in 1947, 46, I believe, if I remember well, the United Nations was born. At that time it was UNO, now it is UN only. So the necessity of the League of Nations, that was discarded. That was no more there. That failed. And after the Second World War, the United Nations was created. Now, there are ample opportunities for lawyers also. You have to study in international law as well, the various covenants the agreements which are made, the international covenants as such, to which if we are signatory, if our nation is a signatory to any of such covenants before the United Nations, where many countries at a time, they assemble for cooperation. So if our nation is a signatory to any of those covenants, we are bound by those covenants to obey those covenants and to comply the terms and conditions of those covenants within the country as well. This is to be like human rights aspect, and there are many other things, environmental aspect also, many other things. Before you go for streamlining, I would request you all to go beyond your syllabus if you happen to have the scope, inclination, because that is very essential. In our times, the syllabus was not so consolidated. We did not ever see a printed syllabus as such. What was our syllabus? The books available were not, there were plenty of books from the old College Street market. We had to find out which is the best book on this subject, like that. And the famous books, of course, the known established authors. The thing is, those days are over. Now the facilities you have through internet and the consolidated syllabus which you have for your academics in the legal profession to begin with. Now with that, you have an ample opportunity to make up your mind when you complete, after you complete, which stream further you intend to choose. So now don't go for to be a corporate lawyer or a litigant lawyer, or I would like to be a criminal, a lawyer on the criminal side. I would like to be a lawyer on the civil side. No, not like that. What I would like to have is, what I would suggest you, that like a general physician, like a doctor, as I told you, you have to know the entire physiology. You have to know the entire law that is placed before you. Entire law means within the limited scope available as per your syllabus. But at the same time, you have to study beyond. As I told you, the philosophy of this law. So philosophy, for everything there is a philosophy. For every aspect of economics, there is a philosophy. For every aspect of religion, there is a philosophy. So for that also, you have to read beyond your syllabus as well. And that will definitely help you, because Elon Musk, the great business tycoon, on my mobile I was watching, that he says that he reads some 500 pages every day. Where does he find time? I don't know. But about 500. Think of reading 100 pages. He reads some 500 pages a day. So knowledge is also an asset, and knowledge without dissemination, without sharing, is of no value. Knowledge does not mean only earning. You have to disseminate. You have to disseminate to the juniors, to the people who are at the receiving end. And at the same time, you must share your experience with your other friends in the same sphere. So, when we end, I may not agree with you, Voltaire says. I may not agree with you, but even then, till my death, I shall uphold your right to say whatever you intend to say, even if I do not agree with you. So this opportunity of being heard, that is the basic of our law, one of the basics of our law. No one should go unheard. You should be patient. You should allow people. Otherwise, to be a lawyer, you have to have the patience no one should go unheard. That is the courtroom practice also. That is the law as such. Opportunity of not being opportunity should be given to every person. You remember the terrorist attack in Bombay sometime in 2015, na? কবে হয়েছিল? 2015, 15 or 20? Yes. 26/11. Which year I forgot? 12. 11/12. Yes. 11/12. That Taj Bengal hotel was attacked and all that. Huh? So only terrorist who was sort of arrested, that was Kasab, right? Yes, Kasab. Yes. So Kasab was arrested. What I want to say is, he did not have a lawyer here in India. So India government provided a lawyer for Kasab. So that is the thing. The India government provided a lawyer to Kasab so that his story also does not go unheard. So what I wanted to say is this, that no one should go unheard. It takes time in our courts, but we succeed in giving justice. Indian court system, there is a delay. There is a delay means, and we say the justice delayed is justice denied. It's a very common proverb, but at the same time you must also know that justice delivered in haste is also justice denied. You should not hurry up to deliver this justice. With that, I end today. Thank you very much for giving me a patient hearing. Thank you.
Okay, basically we had an enriching session with Sir today, and I'm sure that we had got the idea that how the subject can be a really interdisciplinary in nature. Well, we understood the fact that how the concept of state and the concept of polity is really important to ensure the studies of legal studies in the present day. We are very thankful, sir, to have you here, and I'm sure students may stand up and pay your respect and thanks to sir as well.
Thank you.
If you have any more questions, you can just wrap up within very short time. It's already time for this person. Any questions? Please sit down. We may have one or two questions which can sir just have a very short conversation.
Yes.
What made you choose this profession?
What made me choose this profession?
Yes.
Difficult to say. In our days, at our times, we were not so focused as you are. Neither we were so privileged as to be guided. There was no such counseling and all as to go for this profession or that profession. My father was not a lawyer. Not necessarily one's father has to be a lawyer in order to take up this. But the thing is, I found while working only that it was a challenging thing. The degree I bagged rather easily, I would say, but I never knew that I would become a lawyer. But in the field as such, that was very challenging. It has so many vistas, and every day one door opens. Okay?
So, what was your most eye-opening case? What was your most eye-opening or interesting case?
What was my most eye-opening or interesting
Case which you have handled?
In my very early days, I appeared for this Khadim Shoe Company. So Khadim Shoe Company's owner was abducted. Yes, and from here he was taken somewhere. Some ransom had to be also had to be given. It had an international racket, and they're all in jail. One will be hanged, and one of the now many persons were made accused and they were sort of arrested throughout India. I also appeared for one of the accused persons, but he was found to be innocent finally, and I could get his acquittal. So in the entire case, that was that was 24 years back. I am talking about this case. You were very small. Oh, you were not born. None of you were born. Right? None of you were born. So this was a very memorable case which I remember. I remember another case, another criminal case where a person was arrested on false documents prepared by the from the government sector, forged documents. He was in custody for 27 days in different jails in West Bengal, and in fact the TV channels those days made sort of documentaries in my chamber and elsewhere also, taking me into consideration, of course. I was his lawyer. So after 27 days roaming from one court to another, first from Howrah court, then to Diamond Harbour court, thereafter from Midnapur court, and thereafter from Baharampur court, I got his bail. And for 27 days he was in custody. And all on false charges, that means fake warrant of arrest. And the then police commissioner also in his report stated, yes, but what can we do if we get these warrants of arrest from the court? These were all with seals and all, but forged. So I was for that person, for a poor fella who was arrested, and after 27 days I could release him from all the jails. Anybody else? Yes.
My question is that how do you approach a complicated case and what do you learn from it? What moral values do you learn from it after the case gets over?
Now, how do I approach a complicated case? The thing is, say an FIR. I have a client who is an accused who has been arrested. In terms of that FIR, the first information report, police having taken cognizance of the same, there is a case in the court. Okay, criminal case. Now for that, in that case, I have to read and reread. At least 4 times I have to read the FIR in plain and simple terms. Every time I read, when I read for the first time, what does not transpire, transpires when I read for the second time. So that way you read 4 times and more transpires from where you can have your defense. What are the lacuna, what are the inadequacies there? You prepare your defense. So nothing is complicated as such. The only thing is we have to give more attention to it. We have to focus more time on it. Okay?
And any moral values?
Moral values, not from all, but definitely from certain cases we do get moral values. Now, the sense of morality is very relative in a case where you can plead for the either side. You know that your client has committed a mistake or wrong or even a crime, but I have taken up the client's case. Now, in that event, whether releasing him, whether I get the whether the question of moral value at all comes or not, that's a very big question. But the thing is, it is the duty of any advocate under the given law and situation that once he takes up the case of a client, he must diligently and honestly fight that case, whatever be the result. And the law says, yes, that I must, the law says that opportunity to everybody should be given. Nobody should go unheard. Similarly, if my client, even if found guilty later, should not go unheard, and I am instrumental in getting him heard in the court. So the moral value is you must be true to your client there. Despite the fact being that you come to know that he has committed that crime. Anybody else? Yes.
Sir, you said that in the Indian judiciary provides everyone a voice to. The Indian judiciary provides a voice to everyone.
What provides the voice?
India provides, yes, it provides a voice. What about the ones that the government mutes?
Judiciary provides a voice to everyone.
But what about the voices that the government mutes?
The same judiciary that allows the voice which are muted to speak, the same judiciary. So we have to have faith on the system. As it is true that the government mutes certain voices, I am very delighted to have such a question. But at the same time, it is the same judiciary. We have to have this faith on the system. It is the same judiciary where we have to make an attempt, where we have to go on attempting, so that the muted voice becomes vocal again. Thank you. Thank you.